Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, can they help themselves? Self-preferencing and large platforms. There has been a lot of discussion recently about whether large platforms can favor themselves over potential competitors. There's been talk about it. There's legislation that might address it. Today, we're going to talk to an expert who's thought a lot about these issues and find out, is it necessary? Is it a good idea to eliminate self-preferencing? My co-host today is Sarah Zhang. Sarah.
Hello.
Sarah, what are we doing today?
So today's episode is all about the new Senate self-preferencing bill championed by Senator Klobuchar. It's called the American Innovation and Choice Online Act. And joining us today is our guest, Adam. Adam is the founder and CEO of the Chamber of Progress, a new center-left tech industry policy organization. And previously, Adam has worked extensively in the tech industry and in tech policy. And he has recently served in executive positions for Lime and Google. So he's here today to share his perspectives on big tech regulation and on the current effort to address self-preferencing by online platforms.
Well, let's bring in Adam Kovacevich. Welcome to the program. How did I do?
Thanks for having me. Great.
Did I pronounce that okay?
No, you did great.
Okay. So Adam, thanks for joining us today. I think maybe before we get started, let's just make a disclosure here. You work for an organization that is supported by a number of big tech companies who may or may not, who probably would be influenced by this potential legislation and this topic. So we just want to make that disclosure.
Absolutely. Yeah.
With that in mind, tell us a little bit about the self-preferencing controversy and what's going on.
Sure. Well, this is an issue, a question that's sort of circulated around big tech platforms for years. When I was at Google, I actually worked on the company's defense again during the Federal Trade Commission's 2-year conduct investigation of the company. And the question in that investigation was basically a similar question as the legislation currently before Congress addresses, which is whether big tech platforms can favor their own products. So in the case of the FTC's investigation of Google several years ago, it was, can Google display specialized shopping results, specialized local search results, specialized travel results, even though that may be detrimental to Yelp, to TripAdvisor, to vertical search engines and the similar service. And I think that principle is essentially the same principle that's addressed by the legislation before Congress today. Can the big tech platforms favor their own services, even when they believe doing so is useful to the consumer, and it may be detrimental to a supplier? And that's really, I think, what's motivating the legislative conversation is in many cases, suppliers have complained about the impact that behavior has on them.
So you've mentioned that this has been going on for many years. So why do you think that this topic is being targeted by Congress right now? And maybe why they are picking this over many of the other proposed bills and regulations targeting big tech?
It's a great question. I think that one thing is true is that there is a degree of understandable political anxiety about the power and size of the big tech companies, right? Mm-hmm. Apple, Amazon, Google, Meta, these are the biggest, most successful companies in the US. They have millions of users. The choices that they make in their product designs do impact millions of users, but also thousands of other companies, app developers, suppliers. And so I think, frankly, there are pretty high stakes for how they operate, which I think many of the companies would acknowledge. Why this particular idea? Well, I think it's important to say that that there have been legislative proposals that have been offered that have slightly different areas of focus. For example, about a year ago, Senator Klobuchar proposed a bill that would have made pretty significant changes to merger review and conduct review, but that was going to be economy-wide. That was not confined to tech. The House of Representatives, the Judiciary Committee there, headed by the subcommittee headed up by David Cicilline, took a different approach and really decided to focus on the power of the big four companies and identify behaviors that they had heard a lot of complaints about from suppliers. And again, I think that's the key thing here to emphasize that in many cases these are harm to supplier arguments that we're hearing that Congress decided to act on. And they did pass, the House Judiciary Committee passed a number of other bills. They passed a merger prohibition bill for big tech. They passed a data portability bill. But this bill around anti-preferencing, I think, has been the one that's gotten the most attention. Frankly, I think it would have the most impact on the way that consumers use technology services today.
Adam, how would this self-preferencing bill affect a company like Amazon?
Sure. Well, I think it's pretty clear that the way that the anti-preferencing legislation by Congressman Cicilline and Senator Klobuchar is written would prohibit Amazon, for example, from featuring its Amazon Basics brand. This is its house brand, and it would likely also force Amazon to change the way that it offers Amazon Prime. Amazon Prime is essentially its own service as well. The way that Amazon Prime works is it highlights Prime eligible products. It also is funded in part by another program called Fulfillment by Amazon. These programs preference certain products, and Amazon Prime, if you're an Amazon Prime user and you go do search for products on Amazon, your search also preferences Amazon Prime products. So all these things today preference Amazon Prime and the Amazon experience. As an Amazon Prime user, I love that. But I think it would clearly prohibit Amazon from offering Prime in its current form today. I think it also, depending on how it was interpreted by the regulators, I believe it could also prohibit, for example, a new iPhone from coming pre-installed with Apple's own apps, iMessage, FaceTime, etc. And that's because doing so would, I think, be the source of a complaint by rival apps. So Zoom could come in and say, well, pre-installation of FaceTime is detrimental to our app. Or Facebook Messenger could say pre-installation of iMessage is detrimental to our app. And under the terms of the bill, they'd have more of a case than they would have today. And so I do think that's practically speaking how this would work. The other thing that's about the bill is that it's written in a way to be tailored to really the five big tech companies in the House, and maybe a sixth or seventh in the Senate: Amazon, Apple, Google, Meta, Microsoft, potentially also TikTok in the Senate. And that's unusual too, because unlike say traditional antitrust law, Sherman Act, Clayton Act, FTC Act, this is very firm specific. It's very much tailored towards certain firms, and I think in a way that is a bit problematic.
So speaking of problematic, what are your views on the current draft of the bill? What are its strengths and weaknesses? And do you think that it will do an effective job at addressing the problems that it purports to address?
Well, I think the problem with the current draft is really its entire approach. Candidly, it's not one that I think is rooted in a problem that needs to be solved, in the sense that what it sponsors just decry today as preferencing is really integrated service. If I buy a new car, air conditioning, windshield wipers, seat warmers, all these things are pre-installed. That's part of the car being a better car for me. And of course, the rival windshield wiper company could get Congress to pass a law saying that cars can't come with windshield wipers installed. That would be good for rival windshield wiper suppliers, not so great for me as a consumer, because it adds to the inconvenience for me. That's really what Congress is doing here. And I think that, the fact is, and Senator Padilla from California made this point in the Senate markup 2 weeks ago. He said, "I think consumers like when they can go to Amazon or Google and they search for a local restaurant or a product, within a few clicks they can find what they're looking for." That's the kind of convenience that Congress is taking aim at here in the name of helping suppliers, and I just don't believe that's what most people want Congress to be doing.
Is there a worry that the big tech companies that we talked about, the 6, 7, have so much power that they're basically able to erect barriers, and effectively, no one will ever really be able to come in, which in terms would stifle innovation and reduce consumer choice. How would you respond to an argument along those lines?
Yeah, I think that is the argument that's put forward, and a version of it basically is that Google owes Yelp distribution, Google owes websites distribution, Amazon owes sellers distribution, or Apple owes apps distribution. And I think the fact is that if we want to go down that road, that would be probably more of a European conception of how the law should be used to privilege suppliers. The problem is, and I think Europe found this in its case against Google over Google Shopping, is that all these services at bottom do engage in a degree of useful discriminating in order to provide consumers with what they believe. So if I go to Google and I type best pizza in Houston, right, I really want to find the best pizza in Houston, right? And to be honest, if the worst pizza place in Houston is upset that they rank poorly, nobody in government ought to do their bidding. I think that this is a variation of that argument. The fact is that none of these services have really, I think, a distribution. For none of them is these services their sole distribution. So, for example, Yelp. Yelp is a prominent, long-time complainant against Google. Would love to see these bills passed, but Yelp has a thriving mobile app, and many people go directly to Yelp's mobile app to find Yelp reviews, just as they do to Yelp.com. Right? Apple has banned Gab, the sort of the right-wing social network, from its app store because Gab is sort of filled with hate and venom and doesn't have a content moderation policy. That doesn't mean that people can't go to Gab.com if they want to find that. They can, right? It also means they have an Android app that can be side-loaded onto an Android phone. So there are plenty of options for distribution. But I think inherent in that argument is an argument that these platforms owe distribution to suppliers. And my argument is that there are good pro-consumer reasons why platforms don't owe distributions or equal distribution to all suppliers.
It's interesting because I think we as antitrust lawyers would typically have a couple of reactions. One is, we don't like the essential facilities doctrine, which starts to feel a little bit like this. And I think it also goes to the consumer welfare standard, right? Because you were talking a little bit about how this was really about suppliers and making sure there's room for suppliers. The question I have, I guess, is have the big tech companies become so big and so entrenched that we should, at least in their cases, and we've limited it to 6 companies, should we somehow make up or establish separate rules? Yeah, new rules for them because they're so entrenched. Because
I think that's why the details always matter, right? Which is I understand why debate about big tech and regulation starts with a pretty high degree of anxiety and political concern about the power of big tech. As Americans, we're taught to be innately distrustful of things that are big and powerful, and I think that makes perfect sense. But you always have to look at what is the effect of doing so. You mentioned the antitrust bar being skeptical in many cases of the essential facilities doctrine, but that is in fact what the Klobuchar and Cicilline bills would deem the 4 or 5 big tech platforms essential facilities, and for a very specific purpose, which is to articulate that they do have a duty to deal, they have an obligation to the supplier. And my point is that, okay, well, let's play that out. What kind of experience does that result in for the consumer, right? For the consumer who likes the fact that there's an Amazon Basics brand battery that's low cost, and now Congress has passed a law saying that is off limits because that's unfair to Duracell. What have we done? What has Congress done in this? Have they done something? Yes. Have they helped Duracell? Absolutely. Duracell's got to be thrilled, right? They're gonna endorse the bill probably. But where have we left consumers? Better off? I don't think so. And our organization's done polling that has found that there's a very sharp contrast when you ask people, do you think big tech should be more tightly regulated? Generally, people say yes, by pretty large margins. But then when you present to them really kind of both sides, and we've done this in our polling, present them both sides of this argument, just to say, these bills purport to help the suppliers, the apps, the services that may find it harder for their services to reach customers. The flip side is that that's going to be less integrated convenience for you as a consumer. Where do you land? And what we find in our surveys is that voters basically flip from saying we support this regulation idea to being against it. They don't really want government to mess with Amazon Prime or the layout of their iPhone or how a Google search works. That's not what they're clamoring for. I do think it also points out that the high degree to which the debate around this is driven by competitors, right, or suppliers, I should say, right. And again, I do think that there are some in kind of the neo-Brandeisian camp who do actually want to raise the visibility of theories around monopsony and harm to suppliers as a theory. And this debate is in fact a test, right? If you say, I want to help Yelp or I want to help Spotify, who has a beef with an Apple or Google, let's play that out and see what impact that has. And I believe that impact for the consumer and the voter is a negative one, but others might disagree.
Adam, I know in a prior life you worked on the Hill, and your organization is following the politics about it. Talk to us a little bit about the fascinating bipartisan politics of big tech, and I don't mean entirely bipartisan, but how different people on different sides of the aisle are coming together on sort of the different issues.
I do think it's mostly surface level at this point, which is to say that the anxiety around big tech having too much power is shared between Republicans and Democrats. But I do think it breaks down. It starts to break down once you get into the details. In general, Republicans care more about preventing what they see as anti-conservative censorship. The Democrats care a little bit more about the platforms fighting misinformation. And again, there are some more neo-Brandeisian Democrats. It scrambles the allegiances. So, for example, back to Senator Klobuchar's bill, there's a provision in her bill that says that platforms like Apple and Google may not discriminate among similarly situated business applications, right? And the idea is to prevent Apple from discriminating against Spotify, for example, right? Which again, Spotify has been a proponent of this bill. But the way that I read that language, it would also prevent Apple from banning Parler and Gab and 4chan apps, right? It would prevent Apple and Google from engaging in content moderation because, after all, business users who might have their own website or app can also be engaging in hate. But under this bill, it says that they essentially have to have equal access. Well, a really remarkable thing happened during the hearing. Senator Ted Cruz, who's been a vocal critic of tech's perceived anti-conservative speech, said he liked the bill, Senator Klobuchar's bill, because the way he reads the bill, it would deny big tech platforms the ability to censor speech. Now, is that what the Democratic co-sponsors of that bill want? I really doubt it. But I do think that's where the surface level agreement, we got to do something about big tech, starts to fray once there's a closer inspection of the details. And I think the tech policy debate now is mercifully moving past the stage of we got to do something to, okay, let's look at the pros and cons of what you propose.
And Adam, your organization, I think, is more aligned with the Democrats than
That's
it
right.
is with the Republicans.
We're expressly a center left group. I'm a Democrat. All of our team are Democrats, and and I think I formed the organization really to kind of respond to what I saw as I think more and more Democrats, frankly, misinterpreting where their own voters were on this. I believe many Democrats misinterpreted the results of the 2016 election as being as a sort of a sign that that they needed, that voters wanted them to go after tech, but that we don't believe that's true. The polling doesn't bear that out either.
It's interesting also because the Democrats, I think, are not united on this issue. You mentioned Senator Padilla, I think probably Senator Feinstein as well, and members of the California delegation in the House, I would think, have probably expressed some of the concerns that you expressed today. How do you see the bills playing out as we approach the 2022 midterms?
I am going to be surprised if there is enough support for these bills, either of these bills, to come to their respective full floors. The schedule is busy. And in general, party leadership, especially in an election year, tries to preserve floor time for bills that unify their party and paint the opposition party in a bad light. The split on these bills is a little bit more complicated in that there are some Republicans who are for them. There are some Democrats who are for them. It doesn't really advantage the leadership of the Democratic leadership in the House or Senate to bring bills up that are not broadly supported by members of their party. We've spent a lot of time, for example, talking with moderate House Democrats and moderate Senate Democrats, and they are much warier about taking action here. You have to remember, too, that the judiciary committees in both the House and the Senate tend to attract the strongest partisans on both sides, because the Judiciary Committee deals with issues like immigration and guns and abortion and Senate judges. And so there are not as many moderate members of the Judiciary Committee. Once you get bills out of the Judiciary Committee, they face more moderate members of each party's caucuses. And so I do think that that just because there is committee passage of these bills doesn't mean that there is even broad support for them among the Democratic majorities.
So what do you think will happen if the current bill does not pass? Do you think this will go away for a while, or do you think, there's enough momentum right now that Congress will just try again and it will just keep coming back?
Well, I think that I don't think these issues are going to go away. In fact, I do think a lot depends on what happens in the midterm elections this fall. If Democrats continue to control one or both chambers, you could see them continue to push these ideas. If, however, Republicans take over one or both chambers, my expectation is that they'll likely focus more of their energy on content moderation and Section 230, and probably a little bit less on antitrust per se. I do think that you'll continue to see these issues play out at the regulatory agencies. The Colorado AG and several state AGs have a pending case against Google over exactly this question of whether Google can favor its own properties in search results. And there's this, of course, these issues are also at the heart of Epic Games' litigation against Apple, which is currently being appealed. And so, and that is also the subject of a potential governmental lawsuit as well. There could be there are government lawsuits against Amazon by the state AGs. So I think you're going to continue seeing these issues and this question of preferencing play out in investigations and in litigation by governments. But I believe many of those are failed. I think it's pretty clear that the law gives a lot of deference to marketplaces to run their marketplaces as they see fit, even if that is sometimes detrimental to a supplier, so long as it's benefiting the consumer. I think that's pretty clear under current law. But of course, that's what these proposals aim to change. I think it's also clear that Lena Khan at the FTC and Jonathan Kanter at the DOJ have some interest in these same theories. But on the other hand, if these bills fail to attract majority support in Congress, that doesn't bode well for kind of political support for a case brought along the same theories.
And a case brought along the same theories will take years to develop and ultimately years to try. And
I think that's right. I do think that there's, I think that's right. But that, you could say that's true of most of the cases that Chairwoman Khan and Associate AG Kanter will bring. Most of those they'll bring cases that are not resolved until they're probably both moved on to other things. I think that both of them have an appetite for bringing cases regardless of their winnability, and that's a little bit of, I think, of a political imperative maybe that they may be feeling right now.
Well, let's stay tuned. We've seen a bunch of merger cases being brought, but that's because those happen very quickly. Let's stay tuned and see how it all plays out. I think you're right. I think we will see action on the enforcement side. It'd be interesting to see how it plays out on the legislative side. And like I said, stay tuned. Well,
absolutely.
Adam, let's shift gears a little bit. You have had a varied career. You've done some work. You've worked in government for a period of time. You've worked with technology companies. You're now working with an advocacy organization. What advice do you have, given these varied experiences? What advice do you have for young folks as they think about their career and what they might want to try to do to find happiness?
Well, I do think seek variety, and also be open to what's happening in the sense of, when I joined Google, it was only a couple months before I got interested in antitrust as an issue because there were high-profile acquisitions that had happened. One high-profile acquisition that happened soon after I joined. It wasn't an issue I was planning on working on, but it was the issue that needed working on. And so I sometimes see that young people sometimes, particularly when they're going to companies, they're driven by passion. I want to work on X. When sometimes they actually may find that learning about the thing that's valuable to the company, that's important to what's happening, actually might be a better path. Might be a better path for them.
It's funny because on the one hand, we typically advise people to take control of your own career and grab it. But you're right. A lot of times there are opportunities that come up that if you are too rigid, will be opportunities lost if you don't follow up on them.
Well, I have lots of friends who have kind of niche specialties in the law or consulting, and in many cases, I think that was not by design. It happened. They kind of got on that path based on somebody pulling them into something, and they just realized that, this is a pretty good niche for me. So be open to that niche emerging in some unexpected way.
I became an antitrust lawyer because the nicest guy at my firm was an antitrust lawyer, and I wanted to work with him.
There you go.
All right. Well, Adam, tell us different question. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
My wife and I collectively have watched almost every season of The Bachelor and The Bachelorette show. And we now handicap it to the degree that we can predict when different contestants are going to do well or fail. And someday I may write a book about how to succeed on these shows because I have so much accumulated, currently useless knowledge in my head about it.
I suppose you're not eligible to go on.
No, I am not. Just to be clear.
What advice would you have for somebody who would like to be on The Bachelor?
Well, I mean, you should want to win in the sense of watch the show a couple seasons and see how well, it's you see how it's odd to me. People make the same mistakes season after season, and watching a couple seasons and just cataloging what mistakes get people sent home and which things do well for contestants. It shouldn't be that hard, but it boggles my mind.
Do you keep like stats?
No, I do. I should, but no.
I have to tell you, Adam, The Bachelor is banned in my household.
Yeah, well, it's probably for the best. I mean, I'm not saying it's high quality entertainment, but
it is something interesting about you that we didn't know. So,
I mean, yeah.
All right, let's go to our final segment called The Curious Hack.
And now it's time for The Curious Hat.
Okay, when we are together, I typically have a hat, and I hand the hat to the guest. The guest chooses a question out of the hat. We read the question, and there we go. Since we're not together, I have a list of questions that are numbered from 1 to 25. I'm going to ask Adam to choose a number, and I will read the question that corresponds with that number.
17.
Okay, number 17. What was your favorite course in college? Your favorite course in college?
There was a great political theory course, or political philosophy course that I took junior year, and it was about democracy and equality, or democracy. It might have been equality or inequality. The great thing about this course, normal college course, you're always sort of cramming to get all the reading done. Wonderful thing about this course, it was just 3 books. So it was Plato's Republic, Hobbes' Leviathan, and Tocqueville, Democracy in America. And so the great thing about this course was we were able to explore this question of kind of democracy and equality or inequality through these 3 texts in depth, which was such a treat because, again, normally you feel like you're just kind of struggling to keep up. And that was such a fun way. And of course, when you really think about it, a lot of those questions are, sort of perpetual and timeless. So it was a lot of fun.
Is there any course that you took that, looking back on it, you would sort of be embarrassed to tell your parents they actually paid for it?
Yeah, I took I think it was like a cultural studies program about the culture of Los Angeles. And I'm not sure I really played that. But we watched Chinatown, like the movie, for like an assignment. And it was fun. I'm not sure it was very strenuous, though.
We had courses called Rocks for Jocks, like many schools did. But we also had Moons for Goons, which was an astronomy course. I will admit that I took one of those 2 courses. I got a B. Didn't take it seriously enough.
No, I that's the thing. That happened to me too. I had the same experience that in taking a course that was supposed to be easy. I think I played down, or whatever the expression would be. But yeah, didn't do that well. Played
to the competition. And there you go. Well, Adam, thank you so much. Maybe we'll have you back to talk as things develop.
Great.
And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.